Welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Guys, today's presentation is going to deal with knowing your enemy. So let's get right to it. Know your enemy. Inside the foreclosure mill, the enemy of my enemy is my friend. That's something to keep in mind, guys, when you're fighting foreclosure. Foreclosure law firm mills. Here's just a few. And there are many. You probably heard of some of these. And I'll go down this list so you can look at them all. Logs, McCalla, Raymer, Liebert, Pierce, Hinchon, Culbertson, Gadati Berger, Messner Reeves, Marinowski Law Group, Reed Smith, BWW Law Group, Rosenberg and Associates, McCarthy and Hothus LLP, Brock and Scott, Cadellis and Associates, Albertelli Law, Orleans PC, Orleans Morin, Phelan, Halligan, Diamond, Jones, Pierce and Associates, Robertson, Annis, Vetters, and there's many more, but this just gives you, well, here's some more. Aldridge, Pite, KML Law Group, Troutman, Pepper, Hamilton, Sanders. Okay, so these are throughout the country, and what they do is handle all the foreclosures for the servicers inside the foreclosure mill contract system. They're not advocates, they're vendors. That's something to remember, guys. The structure of the relationship. Servicers like PHH, New Res, SPS, Penny McFay, or Rushmore don't hire a law firm case by case. They sign a master retention agreement with the foreclosure network, such as Logs, LPS, Default Solutions, now as Black Knight, Fidelity National Service Link Legal Division, Marinowski, McCalla Raymer, Shapiro, and Denice Consortiums. These contracts set flat rates for each task. For example, $400 for drafting a complaint, $150 for a motion for default judgment, $200 for a summary judgment brief, $50 for filing and recording fees. Result, attorneys are paid per action, not per hour, incentivizing speed and volume, not accuracy or due process. No retainer, no real client. The vendor model of foreclosure law firms. Let's talk about this. The myth of attorney representation. In an ordinary case, a client hires a lawyer under a retainer agreement, which defines the attorney-client relationship, specifies hourly rates or flat fees, confirms the attorney must act under ethical and fiduciary duties, and give the client direct control over decisions. But foreclosure mills do not operate this way. They don't have a signed retainer agreement with Deutsche Bank or U.S. Bank Trust. Instead, they operate as third-party vendors within a servicer-managed network, often contracted through Black Knight Attorney Network, which was formerly LPS Desktop or Vendorscape, Logs Network, Provest, ServiceLink Legal. These firms are paid per action, not per client consultation. How it really works. The servicer, not the trustee or trust, uploads a foreclosure referral through a web portal. It might say, file a judicial foreclosure for loan number blah blah blah, attached assignment from MERS to Deutsche Bank, referred to Rosenberg and Associates. The law firm never meets or communicates with Deutsche Bank or its trustee. The client in practice is the servicer's default department or even Black Knight's portal acting in behalf of the servicer. The instruction package contains all documents to be filed, sometimes even the pre-signed affidavits and assignments. There is no attorney discretion. The firm simply executes the task, uploads the status updates, and bills the flat fee. Why this matters? Because there's no true retainer. There's also no verification of facts. The attorney doesn't confirm ownership of the note or validity of the assignment. No fiduciary responsibility to the trust investor. The servicer dictates everything. No independent judgment filings are generated to meet ethics, not to ensure truth. That's why you see so many false affidavits, forged allonges, and contradictory assignments. The mill is simply following a workflow template, not doing legal analysis. The hidden network behind foreclosure mills. Okay, so this is kind of a table showing you this. For instance, foreclosure mill law firms like Logs, Hinchin, Culbertson, Reed and Smith, they draft and file the pleadings, fabricate lost note affidavits, and push default judgment. The role for title companies like First American Title, Fidelity National Title, Chicago Title, CoreLogic, and others their function is to issue or re-verify defective assignments and provide notarizations to cure breaks in the chain of title. Document fabricators like Black Knight, formerly LPS or DOCS, Mortgage Electronic Registration Services, MERS, Nationwide Title Clearing, their function is to generate robo-signed assignments, allonges, endorsements, and affidavits on demand for servicers. And the servicers' trustees. PHH Mortgage, New Res, Shell Point, all these are the servicers. They direct the mills and feed data to the title vendors for document creation. Now let's look at the big picture, why this matters. They run thousands of files with flat fee milestones. Quality collapses under throughout pressure. Your counter strategy, precision, patience, and procedure. Servicer to the mill, to the substitute trustee, to the sale, to the eviction. So who's actually doing the work? Attorneys of record, signature and court appearances, paralegal pods, templates, e-filing, mailings, document, vendor, notary assignments, allonges, and affidavits. Service liaison pushes milestones, approves fees, red flags. Okay, so these foreclosure mills, they want to hire new graduates. They want to hire temps, and they have a high turnover. Okay, so a lot of times they don't even read the draft or read the filing, which means they make a lot of mistakes. The money, milestone-based billing, typically flat fee triggers the servicer's milestone-based payment system. Each legal event, demand letter, foreclosure filing, judgment, sale, and eviction triggers a flat fee payment. Show us how delays or missing documents mean no payment, creating pressure to cut the corners to fabricate missing assignments. File complaint equals $350. Obtain judgment $800. File deed $400. Consequence, no milestone, no payment. Delays hurt them more than you. Notes, this explains rush to premature motions and recreated documents. The hidden cost pipeline. How homeowners fund the attack against themselves. Servicers charge legal fees directly to the borrower. Every time a foreclosure mill drafts a complaint, prepares a lost note affidavit, or files a motion, the servicer adds these charges to the borrower's account ledger as corporate advances, legal fees, or foreclosure expenses. These fees appear quietly on the monthly mortgage statement, sometimes as vague line items like attorney's fees, foreclosure costs, property preservation, corporate advance billing. And why this is a problem. The borrower is literally being billed for their own prosecution, financing the mill that's trying to take their home. The FDCPA and RESPA both restrict this if the fees are not actually incurred or if they're unreasonable, excessive, or deceptive. Many of these fees are pre-judgment before any court order, which violates state foreclosure laws and the mortgage contract itself, since legal fees can't be charged until actually incurred or approved. Here's an example. PHH Mortgage and Ocwen. PHH and its predecessor Ocwen were repeatedly caught adding unauthorized legal fees from their foreclosure vendors, sometimes thousands of dollars for law firm review when the borrower was still in loss mitigation. These were later written off or settled under the CFPB enforcement actions and for improper servicing practices. The Black Knight Connection. Interesting name, right, guys? This loan servicing platform, Black Knight MSP system, automatically posts these legal fees as part of the recoverable corporate advance category. This means that as soon as a foreclosure mill enters a billing code in the MSP system, the amount shows up on the borrower's account ledger. No human verification needed. The servicer then demands that these same fees in the proof of claim, if you're in bankruptcy, or in the foreclosure complaint as part of the total amount due. How to spot and challenge it. Demand servicing records and loan histories through discovery, guys. Look for line items like this, LGL fee, CORPADV, You see how they put them on there like that? Cross-reference the dates. If they billed legal fees before any foreclosure filing or during a QWR period, that's evidence of FDCPA and RESPA violation. And you can always file a qualified written request specifically asking to identify and itemize all legal fees, attorney fees, corporate advances charged to my account, the date incurred, the vendor paid, and the invoice supporting each charge. From public review disclosures like Glassdoor. You can look these companies up on Glassdoor to see what they say about their own company. You'll find poor management, training, procedural defects, overwork, burnout, boilerplate, cut and paste errors, and high turnover. New lawyers unfamiliar with the record. Yep, that's what they're doing. How to use that knowledge properly. Audit everything for typos, wrong docket number, bad notarizations, calendar, and enforce every deadline and follow your local rules. Force authentication for each exhibit they try to give you. Request originals, loan level data when standing is contested. How the coordination works. The service request. The servicer notices the loan is in default and asks for its foreclosure counseled for a complete collateral documentation. Mill to vendor handoff. The law firm contacts the document vendor, like Black Knight, to retrieve and recreate missing assignments or longes. The title company interface. A title company under like Fidelity National Title records the new assignment to clear title for foreclosure, often backdating or using robo-signers. This is where you find your fake assignments that the assigner had no authority to assign anything. Notarization ring. A notary employed by the title company or vendor stamps the fabricated document, creating the illusion of authenticity. Filing a foreclosure. The mill files a false assignment in county records, then uses it as prima facie standing in the complaint or trustee sale. Incomplete discovery undermines summary judgment as well, guys. How foreclosure mills try to push judgment before the truth comes out. Summary judgment is what they try to file, guys. It can only be granted when there are no genuine issues of material fact, but when discovery is incomplete or obstructed, the court cannot know whether factual issues exist. So, under Rule 56D, the Federal Rules of Civil Procedure, and the state equivalents, a party opposing summary judgment may show by affidavit that it cannot present facts essential to justify its opposition because discovery is still ongoing or withheld, where a non-moving party has not had the opportunity to discover information. Okay, let's go over the foreclosure mill tactic. Mills like Rosenberg and Associates, Logs, or Marinowski often file a motion for summary judgment before responding to discovery, ignore requests for production or interrogatories, claim irrelevant, privileged, or not in possession, then argue no facts are disputed, when in truth they've withheld the very evidence that would create the dispute. They know that if discovery were completed, the homeowner could prove that the assignment is void and fabricated. The note was never transferred to the trust, the servicer lacked standing, and fees were illegally assessed or billed. Okay. A pro se defendant should always file an opposition stating the Rule 56D or the state equivalent. Attach an affidavit stating discovery is incomplete and the information sought, such as the chain of title, assignment, validity of servicing records, is essential to the defense. Courts routinely deny or defer summary judgment when key documents are missing, like the note, launch, complete payment history. The movement refuses to comply with discovery. The opposing party is actively seeking evidence to oppose that motion. Misrepresentation to the court. When PHH files the complaint as Deutsche Bank as trustee in care of PHH Mortgage, it conceals the fact that the real party, PHH, is a debt collector, not a trust beneficiary. The plaintiff, Deutsche Bank, did not authorize or sign the pleadings. There is no retainer agreement between Deutsche Bank and the foreclosure mill. PHH is using the trust name to lend false legitimacy to a foreclosure that has no standing to pursue. That's a material misrepresentation to the court, and it mistakes misstates both agency and ownership. Now, if the homeowner sues the bank as a plaintiff, it's the same thing. The homeowner is the plaintiff in a quiet title wrongful foreclosure suit. The foreclosure mill law firm is usually still operating under the same master servicing agreement, but now they're defending instead of prosecuting. The servicer keeps the same contractual pipeline. The law firm's contract is not case-specific. It's part of a standing vendor agreement between the servicer, like PHH, and the foreclosing attorney network. That contract covers both offensive and defensive work, meaning that the same mill that filed the foreclosure can also be assigned to defend any lawsuit brought by the homeowner that challenges the foreclosure, the assignment, or the trust. The servicer simply pushes the new defense referral through the same Black Knight or logs portal. Example, if PHH sends a foreclosure referral to Rosenberg and Associates, the borrower later files for a quiet title action. PHH sends a new task order through the same system to defend the quiet title case. So the law firm is not acting under a fresh retainer. It's still bound by the same vendor terms, the flat fees, the tight timelines, and no independent client contract. The plaintiff trust, like Deutsche Bank as trustee, still has no role. Even in the defense posture, the trustee or the trust doesn't appear to sign anything. The servicer PHH authorized the defense in the trust name. The law firm files appearances as attorneys for Deutsche Bank as trustee, but Deutsche never retained them and never paid them and probably has no idea the case exists. This perpetuates the same misrepresentation that we described earlier, only now it's on the defense side. So the fee structure remains the same. The law firm bills by the flat rate task. $350 for an answer, $150 for a motion to dismiss, $400 for per hearing appearance. And these costs are advanced by the servicer and then charged back to the homeowner's accounts as legal fees. So even if the homeowner sues to clear title, they're often funding the defense through their own loan balance, which is a bitter irony that's worth highlighting. Why this matters in quiet title strategy. This means that your discovery and arguments can target the contractual control issue. Produce all attorney-vendor agreements governing your representation in this case. Identify the entity that authorized you to appear on behalf of the named plaintiff. State whether your firm was retained through a servicer portal and provide the referral authorization. This exposes that the defense is being run by the same foreclosure mill network, not by any real creditor or trustee, reinforcing the argument that no party with lawful title or interest has appeared. In short, when the homeowner becomes the plaintiff, the law firm doesn't change its alliance or contract, it just switches from offense to defense. And conclusion here, guys. The foreclosure crisis is not driven by lawful creditors, but by a network of servicers, foreclosure mills, title vendors, and document fabricators operating through automated systems like Black Knight. These mills have no true retainer agreements with the supposed plaintiff banks, yet file cases in their names using defunct trusts and fabricated assignments to create the illusion of standing. Homeowners are then billed for the legal fees used to foreclose on them. When discovery is incomplete, these firms rush for summary judgment to hide the truth. Understanding this hidden machinery of who the real actors are is how they profit is the first step to defeating them. Okay, guys, I know this was a lot of information, but I hope it was good information for you guys. If you have any questions, you can send me an email to foreclosurehelp777@gmail.com. And as always, everyone have a blessed day.